extend their visa status, though, there are long-term negative impacts for them, though.
Okay.
Because we are living in a culture where, let's say, mother-in-law comes in, or the parents come in, they live in a hotel instead of living in their daughter-in-law's home. That's how the culture is. And I'm not telling what is right, what is wrong here.
Correct.
Now, so when people come here and stay for a long period of time, the problem here is that when they want to revisit United States, that means there may be a problem there. For example, if somebody's parents come here for 6 months and they extend their stay by about 6 more months and 1 year, and then leave the country to India and then come back immediately, though, maybe in 2 or 3 months. The CBP will look into it. Is this person actually visiting India or is visiting USA? It looks like more they're visiting India and staying in the United States. So they may reject their entry into the United States. That's one problem that they face. The second issue is that the passport visa is valid only for 10 years. Okay, most of the passport visas are valid for 10 years. When people go for extension of the visiting visa, though, when they see that this person has stayed for long periods of time in the United States, more than 6 months, then there is a good chance they may reject the B2 visa, thinking that this person is actually staying in the United States and visiting India. That's the second reason why I don't recommend people filing the B2 application, B2 visa. Though. The third reason is that sometimes they reject the B2 visas. When they reject the B2, when I say B2 extensions, when they reject the B2 extension, they are in United States. That means that they stayed unlawfully in United States for a period of at least 1 day, 2 days, or 3 days, whatever the time period. Now, if that happens to trigger, the passport visa, which is there for 10 years, is invalid. They can't use that to come into the United States.
Oh, that's interesting. Okay.
Right. And then sometimes what happens when they file the B2 applications, technically they do some mistakes. And if they do some mistakes and get rejected, and within 6 months period, they didn't file for it. Technically, they overstayed on their visa. That means that their visa is no longer valid. They have to go for stamping again. And when they want to go back stamping again, though, what will happen is that they see that these people have stayed more than 6 months, there is a good chance they may get rejected. So unless there is some medical reasons for the applicant, not for somebody else, and they want to stay in the United States, that makes sense for them to apply for the extensions. Otherwise, do not file extensions of the B2 visa.
Okay, got it. So any other thing that we need to look out for, or is there any help for people who have overstayed, sort of their welcome?
Right. Please make sure that when you overstay in United States, the passport visa is invalid. Don't use that. There are a lot of times people try to do it. When they try to come into United States, they have been deported, detention, they were put in detention for 2 or 3 days, and they were being sent back. That's a very horrible thing, especially for the parents when they come to United States, spending time in jail. That's one thing that I strongly recommend people. When a overstay is there, always consult a lawyer to make sure that they get the stamping before they come back into United States. Most problems that we see is on this one. And of course, getting the visa rejected extension as because they extended their B2 visa, even though they didn't overstay, they extended their B2 visa is the common thing that we see.
Okay. All right. Thank you, sir. Anything else that you'd like to add to this before we proceed?
We can go to question and answer.
Sir, any other updates before we go into our callers and questions about the second round of selections? Is there going to be another round? Any update on that, sir?
We are expecting another round, but that's going to come somewhere in November of 2023. That's where the problem is. Until then, there will not be any third round because they have given a deadline to apply. So after the deadline is finished, then only we can expect another round of selection. Though we are expecting, because of a lot of duplicate filings and people are not filing the H1Bs, even though they got selected in the lottery because of the duplicate filing, we are expecting a third round. That's our guess. Don't quote me on this. Hey, you told me third round. No, that's our estimate. We estimated the second round, it happened. We're estimating now the third round. Also, with regards to the October visa bulletin, where 56 congressmen wrote a letter to the administration.
Yeah.
There was a briefing on not as a briefing, it was a press in the press conference though. The question was asked by a journalist about this particular letter.
Right.
The administration kind of tried to say that, hey, this is the Congress who is supposed to do this, not the administration. They tried to put the ball in the Congress court. Now remember, Nitya Garu, it's the Congress who put the ball in the administration.
Administration's court, yeah.
Now the administration is trying to put it in the Congress. I don't know whether the administration does not understand that the Congress is dead and they don't pass. There are a lot of things that the administration is doing in the immigration without going to the Congress. Why can't you do the same thing when it comes to the, why can't you do the same thing when it comes to the business immigration? So that's something that I don't know why they're not doing it. That's something that now, is it confirmed that they are going to pass this one to the Congress, or will they do? They have not confirmedly said it in the press hearing, though. I mean, we have still small hope that they may still do it by October. So we'll have to closely watch the October visa bulletin, which is expected probably next week, to see if they are going to make any changes in there and make everything current. In the meantime, I urge all the people who are waiting for the green card, who are not waiting for the green card, who would be waiting for the green card, please write letters to the congressman. Our TVASIA people have put that in there, the link where you can go and a draft of the letter has been created for you. Please use that to send it to the administration, where we're requesting them and make all the dates current, because it's going to make the life easier for traveling, makes easier for changing the job, makes easier to buy the house, makes easier to do a business, makes easier. They are going to collect more taxes by doing this priority date current. So please write letters to the congressman. The draft is provided for you.
Gotcha. Thank you, sir. Thank you so much. All right. Okay, let's start taking our callers. Our first caller for the day. Okay, caller with number ending in 1084. 1084. We're ready for you now. Hello?
Hello.
Hi, ma'am.
Hi, thanks for taking my call.
Sure, ma'am.
My name is Ramya.
Go ahead.
Yeah, I have a question regarding B2 visas. Actually, I'm planning to apply B2 visas for my parents and also like my mother's sister and her son, like my cousin. So my question is like, is it a better idea to send all of them together as a group, or just separate out my parents and my aunt and her son into two different groups?
I would recommend to have two different groups. One to your mom and for your dad. One to your Mausi and your cousin. That would be much better.
Okay. And another follow-up question is like, will there be any problem like if I be the sponsor for my even aunt and cousin? I mean, my cousin is like he's a graduated. He's graduated and also like he's preparing for civil for last couple of years. So.
There is no problem. There is always a tendency for younger people not to be given the visiting visa. I may recommend actually to have your Mausi and your cousin separate rather than clubbing them together, though. That would be in a much better interest, though. So yeah, there is always a chance that, especially for younger people, though, they may reject the visa because they tend to say, oh, this guy is going to settle in United States after coming to the United States. There's always a chance for it, but take it, what do you got to lose? At the most, it will be rejected. It won't have any negative consequences if ever he wants to come back again at a later date. So let him try it. But I would rather want to separate your mom and dad in one application, your Mausi in one thing, and your cousin on the other thing. Okay?
Okay, got it. Yeah.
Thank you.
Yeah, thank you.
Thank you.
Yeah.
Thank you.
Thank you, ma'am. Thank you for calling. Rahul Garu, also, while we are on the topic of this B2 extension, how do people need to weigh their benefits of staying longer versus the long-term risks of applying for the B2 visa extension?
So you have to look into, let's say, for example, if, one of the person has a cancer and then, well, that's a big deal. You are going through the treatment. Then definitely, I would say that, well, cancer treatment is better than for them to return back into the United States at a later time. I don't care. So I would go for the cancer treatment would be important, and then I will file for the extension. But if it is just, okay, you come here for 6 months for your daughter's pregnancy and then you want to extend it though, definitely don't do it though. The reason is that your chances of coming back, the mother's chances of coming back will be very less if they extend it though. So you're actually going to kill yourself for coming back into the United States just because of this temporary nature of helping your daughter, with a 5 months old or 6 months old baby. So try not to extend it in that particular circumstances. The other thing is that when people try to come in for especially deliveries that we see though, try to come in the 9th month. Don't try to come in 7th month or before though. Try to come in as late as possible. That's the best thing that you can do. In that way, you can help your daughter or daughter-in-law in a much better way.
Sir, other than this medical treatment that you mentioned, what are some of the other sort of plausible reasons for people to apply for an extension?
Well, for mostly what we see, Nitya Garu, here in the United States, from our community is that pregnancy, when the daughter or daughter-in-law is pregnant, and then when the mother-in-law comes in, she stays for more than 6 months. That's the most common thing that we see, though. Other than that, no, we don't see any people trying to extend it. That's the main thing that we see, that they try to extend it.
Okay. Now, sir, just going back a little bit, I know a lot of people had to stay back under extenuating circumstances like COVID a while ago. Do such people still get impacted, or has there been like a slight sort of, because I know a lot of parents stayed back, some with extension, some without, what's going to happen to those people? Just
for them, there's no flight back to India at all. So there was a ban on flight to go back to India. And even if there was not a ban for a certain period of time, there is other problems too, because people were fearful at that point of time for COVID.
Right.
We lived in those circumstances. We didn't want to send our parents in the flight at that point of time with 500 people breathing the same in a very closed environment though. I understand at that point of time to extend it, and the USCIS also understands the extension at that point of time for the B2. Some of the people have ignored filing the B2 extension. That's a very bad thing that they did.
Yeah.
Because you could file the extension. There is nothing that is preventing you to file the extension. You can print everything online and file the B2 extension. If those people who have not filed the extension, they have to go for the stamping. For those people who filed the extension though, what I recommended to a lot of those people at that point of time is that, let's say, for example, because of the COVID, they stayed here for 1.5 years and they went to India. Now they're trying to come back immediately.
Right.
My question, look, you stayed away for such a long period because of the fear of the COVID. Now you're trying to come back soon. It doesn't look good. Wait for a year or so before you come back into the United States.
Gotcha.
So that's the most thing, that if you ever had to extend the visiting visa, don't try to come back within 3 months. Try at least stay 6 months in India before you try to come back and visit.
Okay, that makes sense, sir. Thank you. Let's take our next caller, Randy. The caller with number ending in 4893. 4893, we're ready for you now. Hello? Hello?
Yeah.
Hi, sir.
Yes. Hi.
Hi, sir. You called us.
Yeah, ma'am. My name is Deepak.
Hi,
I
Deepak.
came to the US in the last October. Yeah. Last year, October, on H1B visa. In the month of May this year, I have got another opportunity from another employer, but my previous employer is not willing to give me the pay stubs and the W-2 form. So in this case, like, what can I do?
Is it paying you?
And my transfer was initiated and I got the RFE with the new employer.
But did he paid you for that period of time?
No,
You said,
no, sir.
Okay. So what you can do is that you can file something called a WH4 complaint to the Department of Labor that your company has not paid you the money for that period of time. And then you show the complaint to the RFE response saying that, look, I was available to work for this guy did not work. He violated, I didn't violate it. Here's a complaint I made to the Department of Labor. So please approve my H1B approval.
Okay.
It's called WH4 form, And you can complain to the Department of Labor that from October to May of this 2023, he did not pay you the salary. He's supposed to pay you the salary for that period of time. And you can complain to the Department of Labor. And they do act on it.
Okay, sir.
Okay, thank you.
Got it. And in this case, like, will the immigration team will consider the past 6 months, I don't have any, maybe the status, or I don't have any work, right? So will they consider that, and will my H1 get revoked or cancelled?
There is a possibility for it, depending on at the time when they filed the H1B, was it a genuine H1B? Was it a fraudulent H1B? If it's a fraudulent H1B, they may revoke the H1B, saying that you have never been counted toward the H1B number because the company has filed a H1B when there is no job. That happens very frequently with some of the companies like yours, though. Yes, there is a chance for it. Okay?
Okay, sir.
Okay then.
Yeah.
Thank you.
All right. Thank you, sir. Thank you so much for calling.
Thank you.
All right.
Yeah, thank you.
Thank you. All right. I'm going to take a couple of questions, sir, before we go to our next caller.
Nitya Garu, I didn't ask him one question. Sometimes I don't. And they do answer the questions, and I don't want to have them answer the questions in the TVASIA, though.
Okay.
So the question I was supposed to ask him was, hey, did you pay any money for this company to bring you into the United States?
Okay.
And if you pay any money for bringing into the United States, so that's considered to be a violation of the law. And since you participated in it, they may revoke the H1B. Now, the only money that you can pay is for the premium processing of the H1B you can pay. But otherwise, you can't pay the legal fees, you can't pay the filing fees, you can't pay any administrative cost expenditure for the company, though. And if the people have paid those fees and they have bought into the United States, though, we see those companies not employing them at all. Their only modus operandi is to bring the individuals on the H1B only by taking the money, and they don't pay the salary, though. So these kind of companies, what happens, Nitya Garu, at a later date, as he was pointing out rightfully, that they may actually get revoked the H1B, and saying that the first H1B was not filed properly, so they are not counted toward the H1B number. That means that they have to go through the lottery again. And that's a fear people will have to. You spend all the money on these companies, you come into the United States, they don't give you a job, and then they revoke the H1B, you lost a lot of money spent on this one, and you still don't have the H1B. You will be na garka, na gatka. So be careful with these companies, though.
Okay. Gotcha. Thank you, sir. Let's take a couple of questions before we go to our callers. All right. Question from MSJ says H1B cap exempt and H4 EAD application can be filed parallel. Do I need to inform my H4 entry exit details in the cap exempt filing? When H4 EAD is pending, can I travel outside the USA and come back? Sorry.
H4 EAD application can be filed. I didn't understand the question. Is he going to file for his H1B and somebody else H4, or his wife's H4, or is his H1B exempt and H4? I couldn't get the question properly.
I think he's asking if he can be both H1B cap exempt and hold an H4 EAD.
Oh, no, because once the H1B cap exempt is going to be approved, it has to be either H4 EAD or H1B cap exempt. It cannot be both. So whichever is approved latest, that will be the count that will take. So if he's in a H4 EAD and he gets a cap exempt H1B approved later on, that means that he's H1B cap exempt. Now, to switch around, he can always do the Margarita switch where he can go to Mexico and come back. But as such, whenever the H1B is approved, that means that he's an H1B, not an H4 EAD anymore.
Got it. Okay. Sir, and when such candidates are, say, living here on the H4 EAD, does that time also get counted towards, like, the 6 years?
No. H4 EAD period will not be counted toward the 6 years, but the cap exempt H1B will be counted toward the 6 years.
Oh, the cap exempt. Yes. Okay. That makes sense. All right. Okay. Janwar Hari says employment-based pending AOS. Advance parole is approved, but EAD renewal is pending. No H1B. Can I travel to India and come back with an expired EAD?
Absolutely. Since the EAD extension is pending, you're allowed to work for 540 days after you come back, after your EAD expires. Since your advance parole is approved, though, you can travel even if you don't have H1B. You will have no problem coming back into the United States.
Okay. Archana Pai says, I'm a professor of surgery working in India. I have passed the FRCSI in Ireland and also passed the USMLE. What are my options to get work visa in the US? And do I qualify for a national interest waiver?
Well, national interest waiver is a completely different thing. National interest waiver does not get you an employment authorization to work in the United States. There are two visas. Since you have completed the USMLE, though, there are two visas that are more easier for you. One is J1 visa, which most of the people use, and also H1B visa, though. Since you may not have completed the part 3 of the USMLE, which requires that you come here into the United States to complete the part 3, you're only eligible for J1 visa, though, not H1B visa. What some other people will do is that they also come on a B2 visa, B1 visa, saying that they want to do some internships in the United States for a period of 6 weeks, 10 weeks, or something like that. She can even apply for the B1 visas. And in those internship period of time, she can give the part 3 USMLE exam. That's why she's eligible for the H1B. So definitely J1 and H1 should be your target right now. In the interim, B2 probably. But once you come here, you can then try the national interest waiver, because it doesn't give you any short-term benefit for you to come into the United States, to be a medical resident, to work in the United States. It's not giving you any benefit. But in the long term, it does give you the benefit, though. So I would recommend J1, H1, in the interim B2. Once you come into the United States, once you are doing a medical residency, probably at that point of time, working on getting the national interest waiver, which is a EB2, is a better idea for you, Archana.
Okay. Thank you, sir. All right. Let's take our next caller then. Okay, caller with number ending in 7965. 7965, we're ready for you now. Hello?
Hi, hello. Hi, Nitya garu.
Hi, sir.
Rahul garu.
Hello, sir.
Hello, Andy. Just quick question. So, kids, Rahul garu, మా సన్ ఇప్పుడు యూనివర్సిటీకి వెళ్ళాడండి. సో ఆయనకి AR11 ఫైల్ చేయాలా అక్కర్లేదా?
What visa he's in?
So when my son goes to college, do I need to file AR11?
No, I know what visa he is. He is a U.S. citizen, green card holder, H1B.
Green card.
AR11. File AR11 for him, yes.
I have to file. Okay, so, sorry, Andy?
File AR11 for him.
Hello?
File
AR11. So, ఓకే అండ్ ఇన్ దట్ ఒక క్వశ్చన్ ఉంది కదా, ఇప్పుడు పెండింగ్ అప్లికేషన్ ఉందా అని చెప్పి అప్లికేషన్ నెంబర్. సో అది గ్రీన్ కార్డ్ అప్లికేషన్ నెంబర్.
జస్ట్
గ్రీన్ కార్డ్. ఓకే ఓకే అండి. అయితే ఓకే యా. అండ్ వన్ మోర్ క్వశ్చన్ అండి, ఇప్పుడు లాస్ట్ టైం మీరు ఎప్పుడు రిజర్వ్ ఫోర్సెస్ కి రిజిస్టర్ యా, సో దానికి ఇప్పుడు అంటే హౌ సూన్ ఐ హావ్ టు రిజిస్టర్ హిమ్ అండి? అంటే మ్యాండేటరీ ట్రైనింగ్ లాగా ఏమైనా ఉంటుందా?
మ్యాండేటరీ ట్రైనింగ్ ఏం లేదు రైట్ నౌ. It's a national registry where you are going to say that if there is any emergency, I'm going to go to the military. That's the promise that you make. And if your child makes that promise, he will be eligible for a lot of scholarships. Otherwise, he will not be eligible for those scholarships too. That's one thing that you need to look into. The other thing is it may always create a problem for your son to become a citizen if he doesn't enroll in these things. It's an online enrollment. It takes only 5 minutes and 10 minutes. What is the negative thing? What can happen? I mean, especially when it was, U.S. military right now is a voluntary military. What is a voluntary military is that people who wants to do it, they come and enroll into voluntary. Can the military be involuntary? Yes, it can be involuntary. For example, in Israel and for example, in Singapore, it is not voluntary. It is must.
Yeah.
And even in Russia also it's a must. So you have to enroll
Right.
in the military and you have to serve for a certain period of time though. Now, it's not a must for us here. It's a voluntary thing. So when you are registering in the registry though, I forgot the name of it, when you register for it, what you're telling is that if there is any emergency that pops up, that I am going to take the arms and go and support the United States. That's what you're trying to tell there. So what we have last seen this kind of thing used is at the time of Vietnam War, though, that was somewhere in 1960s, though, way before probably you were born, where they were being drafted at that point of time. They were being forced to come into, until after 1960s, so after the Vietnam War, we have never seen any compulsory enrollment in the military. So I strongly recommend to take the chances and enroll your son, because that's going to be good for that's going to be good for, I'm trying to pull out the website. That's going to be good for the scholarship, and it's good for getting the citizenship also.
Okay, Andy. Yeah, sure. Yeah, we'll do it.
Okay. Thank you, sir.
Website pair and telsa Andy.
I forgot it right now. I'm trying to pull out what that is. It starts with S, like that's what I remember, but I forgot it. Okay. I'll try to.
Can we go to local recruitment office?
No. Wait. No, don't go to local recruitment. That's different though. Going to local recruitment is different. I will try to get it out in the next session, okay?
Okay, sure. Okay, great. Thanks.
Thank you, sir. Thank you so much for calling. Thank you. No problem,
don't go to the local recruitment without me telling, okay? Thank you.
Yeah, sure, Andy. Yeah, thank you. Okay, thanks.
All right. Good. Let's take our next caller. Thank you, sir. Okay. Caller with number ending in 0786. 0786. Hello?
Yeah, hi Nitya. Hi Rahul.
Hi, sir.
Myself is Abdul. Yeah, can you hear me?
We can hear you, sir. Please.
Okay. Yeah, I have a question regarding my parents. Like they had a visa like for 10 years and recently got expired, and they visited Saudi Arabia, and 2 times the visa has been rejected as 214B. Again, now they have a visa appointment this month, and we just wanted to understand like what should be the reason of the visit. The reason of the visit is just to meet me and meet my daughter, and then to visit some places. Since they already had a visa, this is an extension, right? That is one thing. And
let me ask you this question.
2014, they have.
Yes, sorry, go ahead. You keep going.
Yeah.
2014.
So in 2014, when they came, they had extended like couple of months and has been approved. So they just there for 8 months instead of 6 months. By the time the decision came in, they just left the country, and they were able to come back again in 2018 without any issues.
Yeah, normally, as I was pointing out before, that if the people extend their visas, so when they try to extend their visa while they're in the United States, when they apply for the passport visa extension outside the country, they face a lot of hurdles though. And all they are telling is that your parents are intending immigrants. That's the reason why they're rejecting. And especially that stay of beyond 6 months, even though USCIS has approved that stay though, even though they were allowed to come in 2018, will affect the State Department in giving. So all you can do is that keep on trying. There is nothing special that I can do. That's the only time they stayed more than 6 months, is that right? Or they stayed any other time?
Yes. No, only that.
Okay.
That's the only time.
You just have to keep on trying. That's all I can. Sometimes it may give it a break for some period of time before they apply again though. Try it again
more
to
than
see
6 months. The last time,
try it.
The last time it got rejected was in January.
Yeah, try it again.
Okay, one question, like can they say like they are coming to visit me and for a granddaughter birthday celebration and to do some tourism?
Well, that's the reason why they applied. That's the reason they told before, is it right?
Yeah.
That they're visiting the granddaughter.
No, they didn't tell that reason. No.
Well, whatever.
Last time they said housewarming.
Well, everything, it's a different story. They just want to visit you. That's all the main thing is. Whether it's a housewarming, whether it's a daughter's birthday, it's all the same. They can tell it, but
Okay.
it depends on the officer whether they will, if they will think that they're only coming to visit or they're going to come in and settle in the United States. It depends on the officer there.
Okay.
Okay?
Okay.
Next.
And one other question I have, this is regarding myself. Sorry, I'll be very quick. So H1B, my company name has changed, but nothing else. So everything is remains in. Do I have to apply for an amendment?
If the tax ID number remains the same, only the company name has changed though. You do not have to file an amendment. Get a letter from the HR, and there is a company secretary where the state, like in Texas, they file a thing saying that, okay, law office of 𝐓𝐕𝐀𝐒𝐈 PC has been changed to already in PC. And if you keep that one with you and a letter from the HR, that's good enough for you. You don't have to worry about filing an amendment. Okay, thank you.
Okay, thank you so much. I really appreciate it. Yeah, thanks.
Thank you, sir. Thank you so much for calling in. All right. Rahul, I have a couple of questions for you only before we take our next caller. First question is from Ramses 2. He says, I have an EAD advance parole on EB1 approved. 485 has been filed and received by USCIS on 7/19/23. Fingerprints matched from prior EB2 application on 7/21. Priority date is 1/31/2013. Application in MSc Center. How long do you think it's going to take for me to get my GC?
This guy, I'm assuming, is from India. If he's from India, though, which is backlog, the priority date is not current for him right now.
Yeah.
So if the priority date is current, first of all, the priority date has to be current. Then typically it's taking anywhere between 12 months to about 18 months is the time period that we're looking into if the priority date is current.
Yeah. All right. Next question from Srini Brahma. It says 6-year H1B is expiring on November 10th. Perm was applied on March 21st of 2023. Can we take 2 months of grace period and then apply for a change of status to B2? And can we request our senator to expedite?
Well, senator request is out of question. You can file a lawsuit with Radian PC is filing lawsuits for the delay of the green card application. You can join that lawsuit. You can contact Stephen Brown in our office. That's one thing that you can do. With regards, you don't have a grace period. Grace period is only available when you have the I-94 validity. Since your 6 years is expiring in November of 2023, though, you don't have the grace period, though, after that. So the best option would be to apply for the B2 application within United States and stay in United States until your visa approves, until your I-140 approves, then move on to the H1B. That's one thing. The other thing is you can go outside the country, step and come back once the I-140 is approved. That's the second option. The third option would be that you have until November. So what you can do is that you can spend 25 days in Mexico and come back and spend 25 days in Mexico and come back. You will have that extra 50 days for you to extend though. And remember that when you go to Mexico, even if you don't have a visa approved on your passport though, you can still go to Mexico and come back if you're coming back within 30 days, if you have a valid I-94. That's the reason I say Mexico though. You can extend it. So by 25 days one time, 25 days one time, then you get approximately 50 days. So then you can extend the H1B and then you can go to Mexico again, then you can extend it. There are ways that you can extend the H1B and still work while you are in all this process though. So that's one thing if you're interested in, that may be one thing that you may consider. Because B2, you have to stop working. You go outside you go to India, they may not allow you to work in work and pay. They may or may not, I don't know about that. But if you go with a Mexico option though, you may get both. You may get to work, you may get the pay, you may, and at the same time, you're extending the H1B beyond 6 years. So that's something that you may want to think seriously. Depends on your company though.
Gotcha. So it looks like it's like a longer conversation he needs to have with the attorney.
Right.
To come up with all the options. Okay.
Yeah.
Thank you.
What I recommend, Nitya Garu, is that these people, if they consult it when they come into November, and now we are in September of 2023, the options are very limited though. If they consult an immigration lawyer before though, the options will be plenty to explore. Especially going outside the country, going to H4 EAD options, a lot of different options will be there if they contact a lawyer way before. Now, of course, he doesn't have an option, but for the rest of the people, we strongly recommend though, contact an immigration lawyer way earlier though. Not your immigration lawyer, because they always have a conflict with the company. Contact an outside immigration lawyer to get a clear picture of what are your options. And Nitya Garu, one other thing that I want to tell the audiences is that back in when you applied for the labor certification, perm labor certification, Nitya Garu, I remember in 2007, we have got labor certification approval in 3 days. 3 days.
Yeah.
Okay. Now it's taking almost 11 to 12 months to get the labor certification approval.
Wow.
And back in those days to apply for the prevailing wage, it was 2 weeks affair or so. Right now, it's 8 months. So to file and get the labor certification approval, the time period for some of the companies it's taking is 2 years. 2 years. So for those people who are sleeping around, okay, I'm going to apply my labor certification somewhere in the 6th year. No, you better do it way early in your first term, not even in the second term of the H1B. Please remember that. Things have changed. Otherwise, be prepared to pack your bags and go, or try to struggle like this gentleman is doing. So I recommend to file as soon as possible.
Got it, sir. Yeah, there's all you people who are on IT salaries and don't mind spending like $1,300 on buying a new iPhone. Put that phone aside and get your consultation done first.
Okay.
All right. Question, sir, for you. This is from Ankita Tolani. Says, I work on L1A remotely from Ohio since August of 2022. When my L1A petition was approved, my office address was in New York. Now the office address is in Michigan, I think. MI? She says, MI is Michigan?
Yeah.
Or,
so
but she does continue to work from Ohio, so she's asking for.
I would recommend the company. I would recommend for the company to file an amendment, because when there is a site visit, it's not going to be good. Now, it's not the same violation as the H1B, because LCA, there is an LCA in H1B. There is no LCA in L1A, but it's always good to file, especially both the Michigan and Ohio, both are not coming into the jurisdiction of the MSA. I would recommend to file a amendment.
Amendment. Okay. Cool. Thank you, sir. All right. The MS Paresh says EB3 Priority Date is July 2022. 485 was filed in April and transferred to NBC in June. Status did not change to case is temporarily paused. Does it mean it will get approved when priority becomes current?
Well, it doesn't matter whether it's been paused or not paused though. When the priority date becomes current, you have a chance of getting it approved. Since it's moved to NBC, which is actually good news for you, you just have to wait for the priority date to become, hopefully so it will become current in October for you.
Okay. Got it. Question from Apeksha Nag. She says, my mom recently came on B2 and at the point of entry, the CBP officer very rudely told her to stay only 3 months and not 6 months. However, her I-94 later shows 6 months. Which date should we honor and why was the officer rude?
Normally, when we see the people staying for 6 months, going to India, coming back, staying for 6 months, going to India, or extending their B2 visa and then going to India and coming back, we see the officers being very rude because they are thinking that this lady is actually visiting India, not visiting United States. So that's the reason the officer, typically when we see the officers rude, that's the main reason why we see them. No, you don't have to go with the officer 3 months. If the I-94 is given for 6 months, she can legally stay in United States for 6 months. But I want to keep this in mind that if your mom is spending 6 months very frequently in United States and leaving very less gap in India, though, it may always become a problem. They may cancel her visa. They may deny her entry into the United States at some point of time. So try to keep minimum time in United States so that the next time when she's trying to come into United States, she will not face this kind of problem.
Okay.
So if she stays for 6 months right now, and then she goes to India, tries to come back within 1 month, definitely that's a problem. Now, if she stays 6 months here, and then she goes to India, tries to come back after 1 year, I don't expect a problem.
Gotcha. So Rahul Garu, just a quick question on that. Like, what does the rules exactly state? Because, you know, they do give us like 6 months for the parents to visit. What does the rule book say about, okay, if you've done a 6-month visit, how long is a good time for you to stay, you know, before you're legally allowed back into the US? Because if it's not a violation, then why is it a problem? I'm sure many others have this question. That's why I'm like asking you this.
Right. Right. Good question.
Yeah.
Nitya, there are two kinds of countries' laws in the world, though. One is called civil law countries, where they define it very clearly. In the common law countries, there is some gray area there. So you need to look into the meaning of the law to interpret the law. So India, not China, India, USA, Canada, England, these are all common law countries. So first we need to look into what is the purpose of the visiting visa? To visit United States, to stay in United States temporarily, to visit the family, to go to Las Vegas, to go to Disney World, to come in United States, and not to stay in United States. The purpose of the visiting visa is not to stay in United States, but only visit United States. So if somebody is coming here and staying 6 months, going to India, staying there 1 month, coming back and staying in 6 months in United States, then going back, then coming back and staying 6 months, does that show the intention to are they visiting United States? Are they actually staying in United States and visiting India? So that's the main purpose. The purpose of the visiting visa is to only visit United States. If they see a pattern where they are staying in United States and visiting India, they will create a problem for the individuals.
Got it. Okay.
The pattern is very important. So if somebody got a visiting visa, they never visited, they're now coming, they're staying here for 6 months, and they're going and coming back after 2-3 years, not a problem for them. But for those people who are coming very frequently for 6 months is where we see the problem. Remember the gentleman whose parent got stuck in Saudi Arabia, didn't get the visa, who was on the phone, and this particular lady who is trying to come back, and they yelled at her saying that you can only stay for 3 months. Most probably the reason is that they probably stayed for a long period of time. They're coming back with very short period of absence outside the country. That's where it's creating a problem, because then the intention for them is not to visit United States, but stay in United States and visit other countries.
Okay, got it. Got it. Thank you, sir. Thank you so much for that. Because I'm sure a lot of people have this question, like it doesn't say anywhere that, you know, you cannot visit multiple times in a year, or, you know, we need to stay out for such a long time. But anyway, thank you so much for that. Let's take our next caller. Okay. Oops. Okay. Caller with number ending in 6626. 6626. We're ready for you now. Hello?
Yeah. Can you hear me?
Hi, sir. We can hear you, sir.
Hello.
Please go ahead.
All right, sir. I have a question on visa revalidation. So my H1 is valid until end of the 2024. I don't have visa stamping, but I recently used EAD, AP to travel back to US. Yes, advanced parole. Yeah, my adjustment of status is pending. So can I now my status is parole, is stamped as parole on the passport. So can I go to Mexico, come back using my H1, which is still valid, I-797, which is still valid until the next year end?
What's the reason why you want to go to Mexico?
Oh, having some issues with the employer, so I want to get back on H1.
Well, you are an H1. Are you trying to transfer from? You are an H1B right now. Your H1B is still valid.
Okay. Okay. So
if you're trying to transfer from this company to another company, You don't need to go to Mexico.
No, I'm not transferring right now, but I just want to be prepared for what will happen.
Whatever you want to. For example, you want to extend the H1B, you can extend the H1B. You want to transfer the H1B, you can transfer the H1B. You want to amend the H1B, you can amend the H1B. So you don't need to travel. The only time where we're recommending people to travel is, hey, if you want to file the adjustment of status in a different category, we don't know how they are going to react on it, and we're telling people to go to Mexico. But if your intention is only to be on H1B itself, only be on H1B itself.
No, actually,
you don't need. Are you going to file the adjustment of status again?
Yes, with the other employer, who's my EB3 dates will be, faster than the EB2. So in order to find another 485, I need to be an H1, right? So that's the reason.
Yeah,
from
but
previous employer.
you already filed the 485 application right now. You can always transfer this into the 485J supplement. You don't have to refile it. But yeah, if you want to refile it entirely, yeah, probably you can travel and come back. Absolutely not a problem, sir. Okay.
Being on parole is still valid, right? In the sense,
you can still travel to Mexico and come back on H1B with using the I-797 that has an I-94. Not a problem. You can do that.
All right. Okay. Oh, I checked the online I-94. I-94 is different from the
I know.
I-94 that is on
it says I-94 says it's advanced parole. You're good.
Okay. So sounds good. Thank you.
Thank you, sir. Thank you so much for calling in. All right, let's take our next caller.
One thing, Nitya Garu, remember the gentleman asked for the citizenship.
Yes.
Anybody who is under 26 years of old, though, who were on the green card, though, we recommend that they should enroll in a thing called selective service system. That's the one that I said I don't have it. Don't go to the local military people to enroll in there, but it's sss.gov. That's a website they need to go to register themselves in there. Selective services, though. And if you're under 26 and you're not enrolling it, you may want to consult an immigration lawyer. So for those people who get the green card under 26, if they don't enroll, sometimes it may become a problem for them to get a citizenship. Selective Service System, that's the one. sss.gov.
Okay.
You can go ahead with the caller, sorry.
Sure, Randy. No, I just posted a comment also on the YouTube chat. So the gentleman who's watching the show, you can refer to it later as well. Thank you, sir. And so caller with number ending in 0835. We're ready for you now. Hello?
Yeah, hi.
Hi. Hello, sir.
Yeah, hi. Thank you for answering. So I have a question about one of the immigration, related. So I have received my green card, from employer, but I'm not working for that employer currently. I have never worked for that employer, right? So is there any timeline when I have to join, or do I have to join at all that green card sponsored employer? So I just have to have this question on my mind.
I'm going to tell you something, but I don't want you to speak. Okay. Your intention was to join that company at the time before you got the green card, and you intended to join, but you change your intention after you get the green card. If that's what it is the truth, then you don't have to join technically. You're fine. Will that create any problem in citizenship? No, it won't. Okay?
Okay. So USCIS is not going to come back?
No, revoke your, no. USCIS has never come back to revoke the green card application. USCIS will not create any problem at the time when you go for the citizenship. USCIS will not create any problem at the time when you travel outside the United States and come back. USCIS will not create any problem at the time if you want to extend the green card after 10 years that you didn't work for the company. No, it will not. Okay? Thank you.
Okay. Yep. Thank you so much.
All right. Thank you, sir. Thank you so much for calling, Andy. Now we got a quick question, Andy. This is from Rakesh Bhupalan. Says, I have a CAP H1B petition that's approved through consular processing from fiscal year 2020. I never stamped or used this approved petition. Now its 797B is expired. How can I use it now?
No, you can't. For you to be counted toward the H1B, one of these two things must happen. you must have a valid I-94 in United States, which you don't, or you must have the passport stamped outside the country. So since none of those things happen right now, then you practically are out right now. You have to apply in the lottery again. That's the reason we tell people that if you are in the United States, never go for consul processing. Always go for change of status.
Got it. Thank you, sir. Question from Sundar Mekala says, I'm an Indian and I'm in Mexico now with employer A on a Mexico work permit. Can I do H1B stamping on CAP petition with employer B in Mexico, US consulate, when the 797B petition says Chennai, India consulate?
Absolutely, they can. Even though the consulate is mentioned as Chennai, it does not prohibit a person to go to stamping in any other consulate in the world. Absolutely not a problem.
Okay. And there's a part 2 to that question. It says, I have cancelled without prejudice on H1B visa during my L1B stamp. Will this be a problem during E1C and 485 filing on L1A?
No, it won't cause any problem.
Okay, perfect.
Now I'll explain what he wants to do. I remember speaking to this gentleman. I don't know if it's the same guy or not. Was that he wants to get he should get the H1B stamping with company B. Then later on, he wants to apply for L1A with company A. So when he applies for the L1A with company A, though, his H1B stamping will get cancelled, though. They may cancel the H1B. Now, so he's asking, once he does that, he comes back into the United States, will it create any problem for him to apply the L1A, EB1C? Absolutely not a problem. Why is it important for him to get the stamping for the H1B, even though they may cancel it within 10 days or 15 days after get the H1B is, once a person gets the H1B stamp, though, he doesn't need to be counted to the H1B lottery in the next 90 years. Why not 91 years? I hope, I don't expect that guy to live that long. So for the next, so that's the reason, even though passport stamping is done and it's been canceled without prejudice, of course. Without prejudice means nothing bad about it. It's been canceled because, hey, now he doesn't want to go on H1B. So that will have him counted toward the H1B number. Counting to the H1B number is very important because it's very hard to get to the lottery. Everybody knows you only get a chance in March, and that too 1 in 5, and that too you have to wait until October to join the job. So there are a lot of minus points to it. Once you got in the lottery, you better get it H1B stamped or get the I-94. In this case, is a wise choice is get the company H1B stamped with company B in Mexico, even though it says Chennai.
Okay, got it, sir. Thank you so much. Okay, I'll take another call. Okay, caller with number ending in 4619. 4619, we're ready for you now. Hello?
Hi, Rahul sir and Nitya ma'am. Can you hear me?
Hi, ma'am. Yes, we can hear you. Please go ahead.
I'm good and hope both of you are fine. So my question is, my mother, she got her B2 visa this year, and when she had gone for her visa interview, the interviewer had asked one question specifically as to how many months she would stay in the US if she was granted the visa. So she said 1 month, and then she was granted the B2 visa, and then when she was coming here to US, at the port of entry, she was asked the question once again as to how many months she would stay in the US. So then she said she would stay for 6 months, and then the officer conducted a second level of interrogation, and when they saw her return trip ticket, so then they allowed her to enter into US. So my concern is she stayed here for 6 months, and she had gone back to India, and there in India she stayed for another 2 months. So my question is, can she come back again here? It won't pose any problem for her?
It may pose a problem. Remember that she was here in 6 months. She just stayed in India only for 2 months, though. I would recommend it to at least have 4 months passed after she leaves the country. And when she is coming back, though, limit the period to 4 months instead of 6 months when she is coming back.
Okay.
Okay, that is in her best interest for her. Okay then. Thank you.
Okay, so much.
Nitya, we'll go to the next question, Andy. Nitya, why I'm telling that it's to stay for 4 months, because she stayed here for 6 months. She had a trouble in the secondary hearing. There was an inconsistent statement at the time when she went for the interview, and that has been noted there. And then she's telling it 6 months, and now she's coming back within 2 months. You're asking for trouble at that point of time. And now second time she wants to stay for 6 months. Looks like she's more visiting India than staying in the United States. That's contrary to the B2 purpose though. For example, H1, you're supposed to come here for a long-term period, not to stay in India for a long-term period. So that's B2 is different.
Gotcha. Thank you, sir. All right, I have a question for you. This is from YouTube browser. Says, my friend is on EB2 with a priority date of 2016. He wants to upgrade to EB1. He's in the US and was a small-time manager in the same company. If he manages a person in the US and one in India, can he qualify for an EB1?
It's not one person though. You must be a multinational executive for you to qualify for the EB1C. There's also functional manager, which is very tough to qualify. But typically what we say is that if you have more than 5 or 6, you have a good chance to consult an immigration lawyer. If you have 15, then you have a good chance of winning the case, definitely though. Now, it's not just he worked for a company. He has to work with the same company in India as a manager, Nitya Garu. So let's say, for example, if I've worked with Pepsi in India, now I'm working with Coca-Cola here. Now that doesn't work for EB1C. Right. I have to Pepsi, if I work with Pepsi in India, I have to work with Pepsi only in USA to qualify for the EB1C. That's one main requirement.
If he's working, can he be in the US working for Pepsi and manage people in India and still qualify for an EB1?
Yes. The people whom you manage don't have to be in United States. They could be anywhere in the world for you to qualify for EB1C. Now, I don't know why we have tried this many times. We never had any problem, any officer saying, hey, you're managing people outside this country. They never objected to any of those things until now.
But there should have been a manager for the same company outside of India, outside of the US as well.
That's right.
Okay.
That is right. That's a basic requirement.
Okay, got it. So he might have to move to a different country and still manage people.
Yes.
For the same company.
If he didn't work for the same company outside the country though, then he won't qualify for EB1C. Then he can. And also, Nitya, I just want to point out some of the things where our previous person who wants to get stamping in Mexico, where the guy is working in Mexico. I see a trend. A lot of these Indian guys are going to Mexico to work right now.
Right.
Yeah. I see a trend of that, which I never used to see that before, because people used to go to Canada, but not to Mexico. But yeah, I see a trend right now, people going to Mexico.
Yeah, it's been that way mainly because, one, they're on the same time zone. The weather conditions are a lot better compared to Canada. And I think even food-wise, there's, the closest they can get to Indian food, I guess, is like Mexican food, which gives them a lot of options. Plus, they can fly here back and forth at a very comfortable time rate. So we've been noticing that as well. And a lot of companies that are offshoring are also offshoring to these South American countries now, mainly because of this, lesser time lag. Because with India, they're seeing the morning and night, the 12-hour, 13.5-hour time lag. So they're seeing this. They feel like they can get away with the same pay.
Yeah. We may see more people going to Mexico now.
Yep, Mexico. You have people coming to the US, and then we have people coming from India to you now. So gear up. All right. Question from Narendra Dobala. It says, my parents have had a 10-year visa, but due to personal reasons, they couldn't visit while their visa was valid. Is there any issue if they reapply for a B2 visa the second time?
Absolutely not a problem. All the problems we told was the people who overstayed or tried to stay for a long period of time. If they have applied for the B2, 10 years, they never visited, they want to file it again, absolutely not a problem. They have a very high chance of getting the visa.
Okay. Already. This is from Cadbury. Okay. Says, any FT jobs చేసుకోవచ్చు GCEAD పైన? 2 401ks ఉన్నాయి paraleda?
No. There is a limit for the 401k, though. There is I think it's a 19,000 or 20,000 limit. Since you're crossing that limit, though, it's not advisable for you to cut down one of the 401k.
Okay, but FTE jobs అయితే చేసుకోవచ్చు, right?
Full-time jobs, absolutely they can. 241ks also may be okay too. I definitely want them to one-time check with the CPA with the answer that I told. But there is a limit of 20,000 or 26,000 depending on the age though. You can't cross that limit.
Okay. Jobs అయితే ఎన్నైనా చేసుకోవచ్చు, but this 401k, there is a limit that this category person has to check in on. But other than that, full-time employment jobs, there is not quite a limit, Rahul, if I'm not mistaken.
Yeah.
Okay. Got
they
it.
Can do multiple jobs.
They can do multiple jobs. Awesome. Question from Sunny B says, can we renew the advance parole as early as 180 days, or should it be 110 days? Or sorry, 120 days? Can we renew online?
First, you cannot renew advance parole online. You can renew within 180 days, not 110 days, it's 180 days. One other thing, Nitya Garu, I just want to make a statement is that previously we said that go and apply for advance parole way before 180 days. We have had a lot of success in that thing. That's what we told. But I want to report that we had a denial of advance parole recently where we filed more than 180 days before. I just want to let people know about it. Now, it seems to be an isolated case right now, but it may become common. That means normally you're allowed to file within 180 days EAD advance parole for the 485 that we filed, because advance parole sometimes is taking 17 months to get it.
I know.
So we recommended people go and file it earlier, but we got one rejection. I just want to let other people know there is a chance of rejection. So if you ever filed more than 6 months, so do one thing, file one more time. File 1 year before and file within 6 months. If you get the first one approval, take it. If not, go with the second one. Because anyway, the filing piece is free for you.
Gotcha. I wish they would like charge a filing fee and just give it on the spot and say, okay, your advance parole is valid for 6 months also. I'm sure people don't mind paying that fee and just taking the advance parole as and when it's needed, you know. It's
Nitya Garu, they will take your advice, but they will only take first part of your advice and they will ignore the second part of your advice. They will take the money and they will not give it faster. That's how the bureaucrats work. So we can't, when we propose to the USCIS, we propose it, believe me, they will take the first part of it only, they will not take the second part of it.
That is too funny, Andy. All right, I have a question from Ramses. He had asked a question earlier about, his application was in the MSc Center and he wanted to know how long to get the GC. Now he has a follow-up question to that. He says EP1 was current for India in July of 2023 when the application was received. Visa numbers were available then. So I guess he's still asking why he...
Well, of course, if the visa numbers were available, they will take your application. They cannot approve your application if the visa numbers are not available. Since right now we are in September, visa numbers are not available though. You cannot get the green card unless they have pre-adjudicated the application or already allocated, which is very, very less tiny chance for you to get the approval in that way. So most probably right now, if they want to adjudicate your application, they want to give you the green card, they cannot legally give you the green card. They have to wait for the priority date to become current. And hopefully so, most probably because your priority date is 2013, it should be current, hopefully so, in the month of October.
Okay, got it. All right, question from Animesh Tiwari. He says, I want to take a break on my job pending 485. Priority date is November of 2014. I have a GC EAD. Can I take a 6-month break and then join a job as my dates are not current?
No.
No such luck.
No. You can take a couple of months break, but only under certain conditions, though, which I will tell you. Let's say, for example, you're working for a company called Caterpillar, okay? And you take a leave of absence from Caterpillar for 2 months, though. and then you go and join after, even with loss of pay. That's allowed. But if you leave the job of Caterpillar and then you want to join some other company though, you may have a problem in getting the green card. Remember that the reason why they are giving the green card is that there is a continuous job offer for you. And since that continuous job offer has been destroyed, though, you're not supposed to get the green card. So definitely no to that, to your proposal.
Okay. Rahul, I have a question on this related topic. Say you're on this EAD, you're a part of this company, and you've taken like a 2-month, loss of pay vacation time, and you're traveling somewhere, and in the meantime you get to hear that you've been laid off. What happens then? Do you need to come back right away and make sure you find another job, or are you still okay to take the 2-month vacation and come back?
I recommend to come back immediately. Depending on when the layoff is. If the layoff is happening 2 months from now, or 1 month from now, or 15 days from now, come back immediately. Or if you're already been laid off and you're trying to come back, I strongly recommend to consult a lawyer. There are ways that if you have a job offer with some company, you can come back. If you have a self-employment job offer that's saying that I am going to employ myself, you can come back, but there may be questions about it at the airport. So I would recommend that if you don't have a job, you're trying to come back into the United States, consult a lawyer.
Okay. Good point, Andy. That was what I was trying to get at, because it's not safe for them to travel once they've been laid off, even though they have the EAD and the advance parole, right?
That is right.
Okay.
The main applicant.
The main applicant. Okay. Thank you, sir. Thank you so much. All right. Folks, I know we've had a lot of callers and a lot of questions that have been coming in, and I have been trying to make sure that we do answer a lot of the questions that come in through our live chat as well. Rahul Garu, thank you so much, Andy, for being on the show as always, and for answering all our questions as well. And we look forward to seeing you week after week and answering questions, and not expecting your mansion, but expecting a lot of karma points in return, which is great. So thank you for that, Andy.
Thank you, Ritika.
Okay. And to all our viewers, we'll be back same time, same place next week. And please bring back your questions. Please call us. And like we said, it's easier for us to talk to you on the phone to get a clearer picture. We can always ask you about the missing pieces of information that you can then provide to us while you're on the call, and then you can get a proper answer from Rahul Garu or the other immigration attorneys who are his partners and his people from his firm who are coming and helping us out, time after time and week after week. So thank you so much for that. To all our viewers, have a safe week. We'll see you next week, same time.
Thank you.